The gavel falls, not with a crack, but with a dull, heavy thud that seems to absorb all the sound in the room. It's a sound of finality, of a story ending, but for the family in the gallery, weeping silently, and for the detectives staring blankly at the polished wood of the prosecution table, it feels like the opposite. It feels like a story that has been violently, unnaturally torn in half. Across the room, a man in a tailored suit, a man who the entire world watched, a man who the evidence screamed was guilty, takes a slow, deep breath. He doesn't smile. He simply nods, a small, almost imperceptible gesture. He is free, and the reason for his freedom isn't a brilliant alibi or a surprise witness. It's a word. A single, infuriatingly small word. Technicality. A loose thread in the fabric of the case, pulled by a skilled defense attorney until the entire seemingly solid tapestry of guilt unraveled into a meaningless pile of string. We see this, and we feel a surge of primal injustice. The system, we scream, is broken. It's a game, rigged with loopholes for the rich and the clever. But what if that's the wrong way to look at it? What if these technicalities, these infuriating, case-destroying splinters in the process, aren't bugs in the system? What if they are the system's most essential features? What if they are the last line of defense, not for the guilty man walking free, but for you? To understand this, we have to walk into the heart of the storm. We have to go back to a sun-drenched street in Brentwood, Los Angeles in 1994. The case of the people of the state of California versus Orenthal. James Simpson was not just a trial. It was a national obsession, a spectacle that held the world captive. The prosecution believed they had a slam dunk, a mountain of evidence so high it seemed insurmountable, a trail of blood leading from the crime scene back to the suspect's home. DNA evidence, a new and powerful tool at the time, that seemed to place him at the scene. A history of domestic violence, and, of course, the infamous bloody glove. It seemed impossible to lose, but the defense, the so-called dream team, wasn't focused on the mountain. They were focused on the cracks in its foundation. They understood a fundamental truth of the American legal system. The prosecution doesn't just have to prove their story is likely. They have to prove it beyond a reasonable doubt. And to do that, every single piece of that story, every piece of evidence, has to be perfect. It began with the search. In the frantic hours after the discovery of the bodies, Detective Mark Furman went to O.J. Simpson's Rockingham estate. He climbed over the wall. He was, he would later testify, concerned for Simpson's own safety, believing he too could be a victim. It was during this warrantless entry that he discovered the crucial drop of blood on the white Ford Bronco and the damning bloody glove behind the guest house. This is where the first technicality enters the story. A cornerstone of American freedom, the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The government, the police, cannot simply barge into your home because they have a hunch. They need a warrant signed by a judge based on probable cause. The defense argued Foreman didn't have a warrant. They argued his concern for Simpson's safety was a lie, a pretext to conduct an illegal search. If they could prove the search was illegal, they could unlock a powerful legal doctrine, one with a name as evocative as its function, the fruit of the poisonous tree. The idea is simple. If the tree, the initial search, is poisoned by illegality, then any fruit, any evidence that grows from it, is also poisoned and cannot be used in court. The glove, the blood on the Bronco, all of it could have been thrown out, the case potentially collapsing before it even began. The judge ultimately ruled the search was legal, but the seed of doubt was planted. The defense had shown the jury that the police might be willing to bend the rules, but they were just getting started. Let's talk about that evidence, specifically the blood samples. A vial of blood was drawn from O.J. Simpson. A portion of that blood was entered into evidence. But the defense discovered something chilling. About 1.5 milliliters of the blood, out of a total of 8 milliliters, was missing. Gone. Unaccounted for. This opened the door to the next critical technicality, the chain of custody. When a piece of evidence is collected, it begins a documented journey. Every single person who handles it, every place it is stored, every test that is performed on it must be meticulously logged. It's a chain, and every link must be unbroken. Why? To prevent tampering, to ensure the evidence presented in court is the exact same evidence collected at the scene. The defense pounced on the missing blood. They suggested a horrifying possibility, that a racist cop, Detective Furman, had taken the missing blood from the vial and planted it at the crime scene and on the glove to frame a black celebrity. It was a shocking accusation, but the missing blood, the broken link in the chain of custody, made it just plausible enough to create doubt. Suddenly, the prosecution's most powerful evidence, their DNA link, was tainted by the possibility of a conspiracy. The integrity of the process had been compromised, and in a courtroom, process is everything. It's not just about what the evidence is, it's about how it got there. A broken chain of custody can be enough to render a vital piece of evidence worthless. This idea that the process is more important than the immediate outcome feels deeply counterintuitive. We want justice, and we want it now. But let's shift locations, away from the media circus of Los Angeles to a small, quiet, and terrifyingly claustrophobic room. The interrogation room. In 1963, a man named Ernesto Miranda was arrested in Phoenix, Arizona. He was identified in a lineup and taken into a room with 2 police officers. 2 hours later, he emerged having signed a written confession. He was convicted, and it seemed like a straightforward case. But there was a problem. During those 2 hours, no one had told Ernesto Miranda that he had the right to stay silent. No one had told him that he had the right to a lawyer. He was poor, he had a limited education, and he was facing the full power of the state, alone, in a windowless room. He thought he had to talk. His case went all the way to the Supreme Court, and the resulting decision, Miranda versus Arizona, would fundamentally change American policing forever. It created the single most famous legal technicality in the world, a speech you know by heart even if you've never been in trouble with the law. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. This isn't just a courtesy. It's a direct countermeasure to the immense psychological pressure of a police interrogation. The Fifth Amendment protects against self-incrimination, the idea that the government cannot force you to be a witness against yourself. The Sixth Amendment guarantees the right to counsel. The Miranda warning is the mechanism that ensures a suspect is aware of these fundamental rights. Before, they waive them. A confession obtained without this warning is, in most cases, inadmissible. It's another poisonous fruit from a poisonous tree. Critics at the time screamed that this would handcuff the police, that dangerous criminals would go free, and sometimes they do. Cases are thrown out because an officer forgot, or neglected, to read a suspect their rights. A signed confession can become a worthless piece of paper, but the Supreme Court recognized a deeper danger, the danger of coerced confessions. The history of justice is littered with the tragic stories of innocent people who confessed to horrific crimes they didn't commit, broken down by hours of relentless, manipulative questioning. The Miranda warning is a shield. It's a pause button that gives a citizen, isolated and terrified, a moment to understand that they are not powerless, that the conversation they are about to have could alter their life forever. The great irony of Ernesto Miranda's life is that after his conviction was overturned, he was retried without the confession and convicted again based on other evidence. Years later, he was stabbed to death in a bar fight. The man suspected of killing him was arrested, and as he was put in the police car, he was read his Miranda rights. The rights of the accused don't stop at the door of the interrogation room. They follow them right into the courtroom, creating a minefield of procedural requirements that can detonate a prosecutor's case. Consider the right to a speedy trial, another promise of the Sixth Amendment. This isn't just about convenience. It's a protection against a government tactic as old as time, indefinite detention. A prosecutor can't just arrest you and let you rot in jail for years while they slowly, maybe, get around to building a case. Justice delayed, the saying goes, is justice denied. Memories of witnesses fade. Evidence degrades or gets lost. A person's life, their job, their family, their reputation is destroyed, all without a single guilty verdict. Cases have been dismissed entirely because the prosecution took too long to bring them to trial, a drastic remedy for a drastic violation of rights. Then there's the very composition of the jury, the 12 angry men who hold a defendant's fate in their hands. The selection process, known as voir dire, is a battlefield of its own. Lawyers from both sides can dismiss potential jurors, but their reasons cannot be discriminatory. The landmark case, Batson versus Kentucky, established that a prosecutor cannot strike jurors solely on the basis of their race. To do so poisons the entire concept of a jury of one's peers, proving it is incredibly difficult. A prosecutor can always invent a race-neutral reason, but if a defense attorney can show a pattern of discrimination, a clear trend of dismissing minority jurors, a judge can declare a mistrial, forcing the entire expensive, time-consuming process to start over from scratch. It's a technicality that strikes at the very heart of equality before the law. And what about the evidence the jury is allowed to hear? The rules are labyrinthine. One of the most famous is the rule against hearsay. You can't have a witness testify, "Well, my friend Bob told me he saw the defendant do it." Why? Because the defense has a right to confront their accusers. They can't cross-examine Bob if Bob isn't in the courtroom. They can't question his memory, his motives, his eyesight. Hearsay is gossip, and while it might be true, it's fundamentally unreliable and unfair to admit as fact. The exceptions to the hearsay rule are so numerous and complex they fill entire textbooks, but the core principle is a safeguard against a conviction based on rumor. But perhaps the most shocking technicality, the one that can feel like the greatest miscarriage of justice, is born not from a mistake, but from a deliberate, malicious act by those sworn to uphold the law. It's called a Brady violation. In the 1963 case, Brady v. Maryland, the Supreme Court ruled that the prosecution has a constitutional duty to disclose all exculpatory evidence to the defense, that is, any evidence that might suggest the defendant is innocent. This is not a strategic choice. It is an absolute requirement. A prosecutor's job is not merely to win, but to see that justice is done. When a prosecutor finds a witness who says the defendant wasn't there, or finds evidence that points to another suspect, they cannot simply bury it in a file and pretend it doesn't exist. To do so is one of the gravest forms of prosecutorial misconduct, and the consequences can be earth-shattering. Consider the case of John Thompson. He spent 18 years in a Louisiana prison, 14 of them on death row, for a murder he did not commit. For years he maintained his innocence. Decades later, just weeks before his scheduled execution, a private investigator discovered the smoking gun, a crime lab report containing blood evidence from the crime scene. The report had been intentionally hidden by the prosecutor's office because the blood type did not match John Thompson's. It was a clear, unambiguous Brady violation. His conviction was overturned, and he was exonerated. He walked out of prison a free man, but only after losing nearly 2 decades of his life to a deliberate, illegal, and immoral act by the state. The technicality of the Brady rule didn't let a guilty man go free. It freed an innocent man who was nearly executed by a system that chose to cheat. So why? Why do we have this system that seems to prioritize procedure over results? A system of double jeopardy where someone like Casey Anthony, acquitted of murdering her child, can never be tried for that crime again, no matter what new evidence emerges. A system with statutes of limitations that allow someone to get away with a crime simply because enough time has passed. A system that will overturn a conviction because a lawyer provided ineffective assistance of counsel, essentially giving the defendant a do-over because their first lawyer was incompetent. It feels wrong. It feels like a betrayal of the victims. The answer lies in a single, profound principle, most famously articulated by the English jurist William Blackstone. It is better that 10 guilty persons escape than that one innocent suffer. This is the philosophical bedrock of our entire legal system. Every one of these technicalities, every rule of evidence, every procedural safeguard, is a brick in a wall built around the individual citizen, and that wall is there to protect them from the overwhelming, near-infinite power of the state. The government has police forces, crime labs, teams of lawyers, and a budget that dwarfs that of any single person. Against that power, an individual, especially a poor or uneducated one, stands almost no chance. The technicalities are the great equalizers. They are not loopholes for the guilty. They are a checklist for the government. Did you get a warrant? Did you read them their rights? Did you preserve the chain of custody? Did you turn over all the evidence? Did you give them a speedy trial? If the answer to any of these is no, then the government has not played by the rules that we, the people, have set for it. And the penalty for the government breaking its own rules must be severe, even if it means a conviction is lost. Because the alternative is a world where police can break down any door they want, where prosecutors can hide evidence to secure a win, where a confession can be beaten out of anyone. It is a world of tyranny, where the presumption of innocence is replaced by the presumption of guilt. The click of that closing door, the sight of a person walking free from a courthouse, can fill us with rage. It can feel like a failure of justice, but what we're seeing is not a failure. We are seeing a system that is so terrified of making a mistake, so committed to the principle of protecting the innocent, that it is willing to pay the terrible price of sometimes letting the guilty go. These rules were not written for the O.J. Simpsons or the Ernesto Mirandas of the world. They were written for us. They are a promise that if the day ever comes that you find yourself on the wrong side of an accusation, the full, terrifying weight of the state will be held in check by these small, infuriating, and absolutely essential technicalities. They are the painful, complicated, and imperfect price of freedom. The debate will never end. Where is the line? How many guilty people walking free is too high a price to pay for protecting the innocent? Is a system that prizes procedure over outcome truly just? There are no easy answers. The tension between our desire for retribution and our commitment to due process is a conflict that lies at the very heart of a free society. It's a conflict played out in every courtroom, every day. So the next time you hear of a case thrown out on a technicality, perhaps the question to ask isn't just, how did they get away with it? But also, what fundamental right was that technicality designed to protect? Let me know your thoughts in the comments below. Where do you draw the line? If these deep dives into the machinery of our world are what you seek, consider subscribing for more stories that challenge what we think we know.